Criminal defendants who can't afford counsel must be provided one, but not always. The right to a lawyer comes from the Supreme Court's 1963 decision in Gideon v. Wainwright, which ruled that the Sixth Amendment guarantees legal counsel for anyone facing jail time who can't afford an attorney. But the tricky part is figuring out who actually qualifies as can't afford. There's no single national rule. Each state uses its own income guidelines, usually based on the federal poverty level. For example, in Florida, you can qualify for a public defender if your income is up to 200% of the federal poverty guidelines, or if hiring a private attorney would create what the law calls a substantial hardship. In 2025, that means roughly $30,120 a year for one person, or $41,000 a year for a couple. Even if you earn more than that, a judge can still appoint a public defender if you can show that paying a private lawyer would be unreasonable for your specific situation. In Colorado, the cutoff is more strict. The state public defender's office uses 125% of the federal poverty level as a benchmark. That's about $18,825 a year for one person, or $25,550 for two people. The court also looks at your assets, your debts, and essential expenses like rent, medical bills, or child support before deciding if you qualify. In most states, you'll fill out a sworn affidavit listing your income, your expenses, and your dependents. If the judge finds that hiring private counsel would cause genuine financial strain, a public defender is appointed. So while the Constitution promises a lawyer if you can't afford one, the fine print, the actual dollar amounts, depends entirely in which state you live and how that court defines can't afford.